everyone. Welcome to the 8th East Africa International Arbitration Conference 2020, the first session of the Career Day, a career in arbitration, a truly bright one, I hope, for all the young arbitration enthusiasts who have been able to join us today, despite the lateness of the beginning for beginning this session. I hope you've all been able to hold your horses for the kind of expertise that is here today to advise you, guide you, and provide you with their experience. And so, therefore, we kick off this session of Careers Day in arbitration. My name is Madeline Kimei. I am the founder and principal of iResolve, a boutique arbitration firm that is based in Dar es Salaam, Tanzania. I'll be your moderator today. And of course, the session today, we have the session that is tagged Advice for Young and Aspiring Practitioners. And we have Mr. Andrew McClay, who's a director from the Secretariat, a UK-based firm. He will give us perspectives from an arbitration service provider point of view. We've got Medina Chenge, a partner at DLA Piper Ima Advocates, a firm based in Tanzania, who would look and give us into a dive into the law firm perspective. We then have Mr. Ahmad Khalid from the Nigeria National Petroleum Corporation, NNPC, Nigeria. He will give us his insights from a government perspective as a counsel. And of course, we have the renowned Dr. Emilia Onyema from the SOAS University in the UK, who would give us now the academician perspective on this day in the field of arbitration. So welcome all. Prior to us beginning and understanding that a career in arbitration, of course, does need a lot of investment. You need to invest a lot of time to network and have access to the information, the right information, in order for you to now build that practice and become well versed with the practice of arbitration in all its angles. And as you can see today, we have perspectives from the academicians to the service providers to the law firms and of course the counsel that represent clients in these arbitrations. So just to kick off the day, we'll start off with Ms. Medina Chenge. Ms. Medina is a partner and deputy head of the Banking and Finance Department at IMA Advocates. She's a very good friend of mine. Medina is renowned for her in-depth expertise in handling complex arbitrations with an experience of more than 15 years. Medina gathers praise for her renowned strong track record and stands out expertise in advising top-tier international clients in the telecommunications sector, the mining sector, as well as the banking and finance sector. And my experience with her is within that banking and finance sector, and I can vouch to that. Medina represents both domestic and multinational clients before ad hoc tribunals, international arbitration forums such as the ICC and the London Court of International Arbitration. Medina is recognized for her top-notch advocate skills by her peers and leading international ranking directories such as the Chambers Global. Welcome, Medina. We would like to hear now your perspectives on the African law firm practices with regards to arbitration. And I know IMA has been around for a long time in Tanzania, and it is part of the DLA Piper Africa connection. Please talk to us about your perspectives on arbitration for the African law firm in Africa.
Thank you, Madeline, for that introduction. I hope everybody can hear me. I'm seeing a bit of messages, people stating they can't hear the presenters. Okay, so where do I start? As Madeline just introduced me, I work at IMA Advocates, which is affiliated with DLA Piper Africa. One of our strongest practice areas has been international arbitration. And what we have been seeing, at least in recent years, and I'm sorry, I know I'm going to speak more about Tanzania, but I'd like to think it's more of a common trend in Africa. So arbitration is becoming a very popular mechanism for at least dispute resolution, especially when it comes to commercial disputes involving international or cross-border transactions. Much of it, to be honest, is being driven by, of course, international companies which are investing in Africa. Although in recent years we are seeing some local, investors are also trying to embrace international arbitration. Now, speaking from a Tanzania perspective, the main reason why we're seeing an increase, at least in international arbitration, predominantly have to do with party autonomy. People like to be able to choose who will, of course, represent them when they're in dispute. Arbitration also tends to offer greater flexibility when it comes to the procedure. So, that's always a plus for the parties in dispute. But I think it's more than that. It has more to do with, especially with international investors, they like the tribunal to be neutral. They tend to be very fearful of the local courts. I've noticed there's a perception that they think local courts are very costly, both with respect to time and money, and also that they lack the expertise for the sectors that they have invested in. So hence why they tend to choose arbitration. Another thing which we've noticed why they prefer arbitration is the concept of confidentiality. Of course, it's very sensitive industries that we have represented. It's the mining sector, the telecom sector. They don't like their business to be out there. So that has been one of the other reasons why they have chosen arbitration. And honestly, the whole idea that the tribunal is independent from political interference and bureaucratic issues, that also tends to be a good reason why they choose arbitration. Now, in Tanzania, the main concern that we're seeing, especially for the local investors, is the perceived increased costs in arbitration. At least locally, it's proving to be quite expensive. And a lot of them are very fearful that even in the future, this is going to be a staggering figure which they cannot keep up with. Another thing which we're seeing is there has been an increased trend of African disputes in international arbitration tribunals. But unfortunately, it is not reciprocated, apologies. So when it comes to arbitration practitioners, the African representation is lacking, both legal counsel, arbitrators, even, the secretarial. So this is something I think which is the future for arbitration, at least in Africa. What I can say is, honestly, the reason for this lacuna is the lack of specialization for arbitration, at least in our jurisdiction personally. We don't have a lot of centers which offer training on arbitration. And this is something we have been trying to look to. And of course, I'll speak about this later with the changes in the law. And hopefully this is an area which is an opportunity for the new lawyers coming into the market, because I believe the more lawyers we have who specialize in arbitration, the more vibrant the sector can be. But at the moment, we still tend to prefer to London and Paris, for instance, as a seat of arbitration. And I can say this has a lot to do with, again, the whole idea of investors fearing the national courts. Another reason is they feel as though perhaps the legislative reforms or the court support is lacking for them to actually risk having their dispute determined locally. And hence why, I think I'll speak about this later, it's very important to ensure that our legislative reforms and also our court system, otherwise we will never actually attract the investors that we're looking to in this sector. Thank you, Madam.
Madina, Yes, if I could stop you there and ask you, how important do you feel that the support of the courts and the judiciary in its entirety is, with regards to arbitration, advancing arbitration, and clearing the way, especially from a Tanzanian perspective, and of course from other jurisdictions in general, from your point of view?
Honestly, from my perspective, it's crucial. There is no avoiding it. And I will give you an example from Tanzania, at least. We have a rather outdated Arbitration Act. I mean, it was introduced during the colonial era, and we are still using that. So it hasn't kept pace with the modern world. It does not recognize certain concepts which have become accepted in arbitration. And that coupled, of course, with a judiciary which is hesitant to learn more about arbitration, which just wants to sort of remain confined in the old space, makes it very difficult. Another thing which we have been seeing in Tanzania is with the prevalence of international arbitration, and often it involves the government or other state entities. These tend to be held outside of Tanzania. And most of them tend to be against the government or the state. Now, this has created this atmosphere whereby the government feels as though they're not getting a fair playing field when it comes to international arbitration, that the institutions have been built to somehow ensure developing countries fail. And I mean, case in point, in 2017, we saw, staggering reforms in the natural resources sector in Tanzania, whereby the state said all disputes involving national resources must now be handled in Tanzania, thereby basically stating you can no longer go to arbitration. Now, of course, we have seen a reversal, or at least there are hints that there has been a reversal, but I'll get to that later on. But it is very important to have a legislator and a court system which supports arbitration. Otherwise, we will fail from the very beginning.
Thank you, Medina. And you've brought to light the fact that we do have a new Arbitration Act that has not come into effect, because I am in front of me holding a ruling of the courts, the High Court of Tanzania, and a High Hope International Group, a Chinese company with Jock Textile, that was issued recently by the Honorable Judge Philip Butamo, stating that the act is not yet in operation. And this judgment is as of 12th June 2020. And speak to us about the legislation and the new act that we've been really pioneering to ensure that it is in effect and actually put to operation, and just point out noteworthy changes that are friendly and creating a friendly environment for arbitration in this jurisdiction that we're in, Tanzania.
Yes, thank you, Madeline. Well, the new arbitration is very closely modeled to the UK's Arbitration Act of 1996. So at least for us who are practicing arbitration, that is definitely something which we welcome. It basically now makes a distinction between, let's say, domestic commercial arbitration and international commercial arbitration. The whole purpose of it seems to try and regulate at least domestic commercial arbitration. It now provides, for instance, the procedural steps which are to be followed during arbitration proceedings. It goes as far now, for instance, as to govern arbitration costs and fees and how those can be recovered. It proposes to establish the Tanzanian Arbitration Center, which is intended to, first of all, manage and regulate arbitration in Tanzania. But also to educate, arbitrators, the judiciary, and the public on arbitration in general. And one thing which we all appreciate is it finally offers clarification on how we can go about enforcing and recognizing arbitration awards, because in the past, this has always seemed to be a gray area. You know, the law seemed to be rather clear, but the way the courts had gone about to interpret the law had brought about a lot of confusion when it came to enforcing foreign awards. So I would say it's a positive step. There has been some critics of it, of course, saying, you know, it offers so many avenues for court intervention. But in all honesty, it is modeled against the UK's Arbitration Act. So the beauty about it is, I believe when those avenues are pursued, English decision will really prove of importance here.
Indeed, yes. We will be borrowing a lot of from the English courts in this case, bearing in mind that it does mirror the Arbitration Act of 1996 from the UK, with a little bit of tweaks here and there. But it's been well received, despite the criticisms and the lack thereof of certain features that were anticipated and had not been accommodated. So thank you so much, Madina. We will come back to you during the Q&A session after our other panelists have addressed our participants today. I move on to Andrew McClay. Welcome, Andrew. Andrew is a specialist and an expert accounting witness in commercial and investment arbitration. He has an MA from University of Cambridge, UK, and is a fellow of the Institute of Chartered Accountants in England and Wales. An accountant expert witness accredited by the Academy of Experts, an associate member of the Chartered Institute of Arbitrators, and a certified fraud examiner. He has testified before the ICC, the LCIA, the ITSIB tribunals, and English High Courts, criminal courts, and by way of deposition as well. He has lectured and written articles on international arbitration and anti-corruption matters. He lived in Burundi between 1991 and 94 and is fluent in French and works with arbitration lawyers in London, Paris, and throughout the African continent, particularly. Thank you. Andrew.
Thank you very much for the introduction, Madeleine. And I feel very privileged as a non-lawyer to be a part of the conference today. So a few years ago, I listened to a very moving lecture by Emmanuel Gaillard, who's one of the doyens of the international arbitration world at Shearman & Sterling in Paris. And it was on the subject of what he called the international arbitration community. And basically, he analyzed the world of international arbitration from a sociological perspective and concluded that it has all the sociological traits of being a community. So the participants know each other, they like each other, they go to the same conferences each year, or they used to. They like international travel, or they used to. They work in the same way, they move between the same firms, they know who the top practitioners are, they intermarry, and they're usually quite culturally sensitive to each other. And I suddenly realized that I, as an accounting expert witness who works in arbitration all the time, but is not a lawyer, is actually part of this community, which is why I loved coming to a conference like this, because I feel part of the community and part of being there with you. And actually, even just listening to Madina just then, I realized that the first case I did in Tanzania was about 15 or 20 years ago. And you know, I remember my lobster thermidor in Dar es Salaam. It was great, best lobster I've had anywhere in the world. But it was a great case to work on too. And anyway, the role of a quantum expert witness, it sometimes comes as a surprise to senior lawyers to be reminded by a client that actually the principal reason that most clients start arbitration proceedings is actually to get money back from the other side. Now, I know that lawyers may find that money isn't the most exciting part of the proceedings. It may be that jurisdictional arguments are much more exciting than quantum. However, clients actually want to win money back. And that's why expert witnesses in quantum are quite important, and why generally we get instructed on a lot of cases in both investment treaty and commercial arbitration work. So let me just introduce you briefly to two topics. first the role of an expert witness, and then what we actually do in terms of calculating quantum. So in arbitration proceedings, parties tend to appoint expert witnesses to provide an expert opinion to the tribunal on a particular subject. In my case, it tends to be quantum and the calculation of damages. But in order to support its case, the lawyer will generally include factual witness evidence and also expert witness evidence. And the rules for experts are fairly clear today. They're set down in the CPR in England, and they're set down in the IBA rules on giving evidence. An expert witness's role and duty is to assist the tribunal on a topic that's outside its expertise. And the expert witness generally owes a duty of independence from the party that appointed it, and its duty is to assist the tribunal in coming to the correct calculation of damages. Anyway, the second subject was, how do we calculate damages as experts? And I'll give you two examples from case studies that illustrate that from an introductory point of view. Fundamentally, we contribute to assist lawyers in coming to a robust number and to provide robust arguments to support that number. So, for example, in a mining case in the DRC, which I worked on last year, the minority shareholder in a joint venture had claimed for loss of dividends as a result of the company not making any profits. And the reasons for this primarily, allegedly, were as a result of a bad decision on hedging against the copper price and a result of allegedly overpaying two of its principal suppliers. So my role was to demonstrate, firstly, that even if the company had made any more profits, it would not necessarily have paid any dividends at all. And secondly, in fact, it had paid the market price to its diesel and securities services providers. And also in terms of the hedging, it had hedged against the copper price at the market price at the time. And so that was a rational decision, even if in the future, the copper price went in the opposite direction to what was favorable to it. And finally, that its accounts have been prepared in accordance with the rules of accounting of the OHADA countries, because OHADA countries, West African countries generally, also have an accounting framework as well as a legal framework. That was the first example. The second example, briefly, one of the key issues that comes up today in so many quantum hearings is what I call predicting the future and achieving the required standard of evidence for a tribunal to actually award damages, which is what I tend to look at as reasonable certainty or sufficient certainty for a tribunal. And this is very important because in many cases today, claims are based on what we call the discounted cash flow approach, which is basically, for example, a method of estimating how much cash a nickel mine in Tanzania, to give a topical example, is likely to have generated over the life of its concession. So, for example, in an ICSID case, which I worked on for the government of Egypt, there was a claim for expropriation of an iron and steel plant very early on in the plant's life, before the mine had been built, and at a stage when there were still questions over the quality of the iron ore that was to be mined and what's called the beneficiation process. I'm not an iron and steel expert, but we worked with iron and steel experts to demonstrate that there was too much uncertainty, in my opinion, for the tribunal to be able to make an award based on an assumption that the plant would have made profits in the future, whereas the other side claimed damages based on the DCF approach and an assumption that it would have made profit. In the end, and this is a fairly recent award, it's in GAR or IAR, I think, the tribunal found against the government of Egypt on liability, but agreed with our opinion that the future profits were too uncertain, and so awarded the claim with an award based simply on the amount of money it had actually invested in the plant. So by conclusion, I just wanted you to remember that part of the international arbitration community is more than just lawyers. There are us lovely people who love to be part of that community and get to know you all. And I'd love to chat to anybody in the next couple of days who's interested in damages a bit more. And finally, if you want to read a good book on the subject, I really do recommend a thing called the GAR Guide to Damages in Commercial Arbitration. It'll be in the library of many of your law firms. I've given away a few to copies to firms in Nairobi and in Dar es Salaam, so it certainly ought to be there as well. So thank you, Madeleine.
Thank you, Andrew, and thank you for giving us a different perspective in the work of the international arbitration that you have done, the examples at the outset that you have been a part of, and of course, as you know, lawyers are really not good when it comes to the numbers, and it's usually about the numbers, about the figures. In regards to what is the quantum. The quantum is usually partly the essential factor for the dispute itself. Really interesting that the party are the ones that would, the party is the one that would elect or appoint an expert witness. Can you, provide us with your input? How independent would the tribunal, or would you be if the parties are the ones appointing you as an expert witness?
Well, it is a conundrum, because people say, well, how can you be independent if you've been appointed by and paid for by one party? Mm-hmm. But it's really important. In the UK, it's become very clear that if you act as an expert witness in the High Court and you don't give an independent view, you get criticised by the judge. So the judge has a little bit of his judgment or her judgment, and they analyze all of the experts, and they say, if you haven't been independent, you get criticized, which is really bad for my reputation if that would have happened to me. So in international arbitration, the arbitrators don't tend to give that little criticism. They do occasionally, but it really is clear that our duty is to assist the tribunal. So we do provide one perspective, that's the point of the adversarial system. But we do have to, it's really not on for us as experts to put forward a point of view that can't be supported in any way. I would say it is possible. There are very rare examples where a tribunal appoints its own expert. So there are tribunal appointed experts. And some people ask why that doesn't happen more. But at the moment, it doesn't happen very much. And that's just a fact. I'd be quite happy to be appointed as a tribunal appointed expert if that was better. But the lawyers tend to prefer their own party-appointed experts. And we have to provide a robust opinion, but one that is fair and is not obviously biased in one direction or another. Obviously, there are two sides to a story, so we take a view on that. But our duty has to be to the tribunal, and we sign that on every report that we write. We have a declaration stating that we understand that.
Interesting. So there could be party-appointed expert witnesses or tribunal-appointed expert witnesses, and it's good to understand that the tribunal-appointed expert witnesses are not that common. Can you tell us about how this calculation of future damages is done? Is this just a guesswork, or there's a lot of work to be put onto it? And how can a tribunal make an award about future damages when nobody knows what would happen? We cannot predict. And of course, with the advent of the pandemic, the COVID-19 pandemic, how can you predict the impact with regards to calculating future damages, Andrew?
Well, we just have to do our best. We as accountants are quite used to modeling. So we can model things into the future based on certain assumptions. But realistically, sometimes people think that accountants are the soothsayers. We are the prophets. We're the ones who are able to tell what would have happened in the world in terms of damages. I just think that's not the case. We have to work with the lawyer, with the client, and say, look, if you've got a copper plant in the DRC, how much copper would that reasonably have produced? Well, you can look and see how much copper is in the ground with experts, and then the political dangers and difficulties of the DRC for getting it out of the ground. But one has to work together. But once you work together with the client and the lawyers to guess what the future might be, we are fairly good as accountants at building a model. So based on certain assumptions, we can build a model as to what the future would have shown. And then we have what's known as the discount rate in discounted cash flows, where we then discount the future for uncertainty. So we say, look, in 10 years' time, this plant might have produced 100 tons of copper, but it might not have done, and therefore there's a certain degree of uncertainty around it, and we discount to take account of that uncertainty. And ultimately, a tribunal has to be, and I'm really strong on this, the tribunal has to be sufficiently certain that the projections into the future are reasonable and that the thing would actually have worked. And if you, for example, have got an electricity plant and you've got a power purchase agreement, then that's fine. You might know the future price of electricity. But if you don't know that, or if the plant has never been built, then tribunals tend to go back and say this is too uncertain, or just award damages on some other basis, such as how much has actually been spent on the plant. So we work together to foretell the future.
Thank you, Andrew. Indeed, it is team play, seamless production for you to be able to assist the tribunal in arriving at a reasonable award at the end of the day. Now we move on to look at the academic perspective with regards to arbitration. Dr. Emilia Onyema is a senior lecturer in international commercial law and an associate dean, learning and teaching of the Faculty of Law and Social Sciences, or otherwise known as SOAS, University of London. She is a fellow of the Chartered Institute of Arbitrators, a committee member of the London branch, a fellow of the Higher Education Academy as well. Her teaching and research covers international sales law, law and development in Africa, and international commercial arbitration. As we all know her from the SOAS Arbitration in Africa conferences that have been held across Africa. The Queen's Mary University supported conference, and the alternate tribunal secretary of the Commonwealth Secretariat, a Vitro tribunal in London. She's also a member there. She's a qualified practitioner of law in Nigeria and is a solicitor in England and Wales. She holds a PhD in international commercial arbitration and is widely published in this area. She is the author of the Chartered Institute's workbook on Introduction to International Commercial Arbitration and International Commercial Arbitration and Arbitrators Contract. Now, Dr. Emilia, talk to us about your perspective from an academician point of view, please.
Thank you very much, Madeline. Can you hear me?
Yes, we can.
Okay, great. Thank you so very much to the organizers. Thanks for the invitation. I'm really, really very pleased to have finally been invited to speak at the East Africa conference, which is very, very, very much. Thank you.
You're most welcome, Doctor.
So I think for me, I've heard, we've listened to a lawyer, a legal practitioner, and then we've listened to an accountant who graciously referred us back to Emmanuel Gaya's discourse on the sociology of arbitration, on which he wrote a book as well. And the idea that the world of arbitration, or that community that we know as the international arbitration community, is not the preserve of lawyers. So you do not need to have a law degree to become a member of that community. I think that's really, really important, because we seem to forget that, and all we can see when we talk about arbitration practitioners or those involved in international arbitration or domestic arbitration at that, we just see counsel, we see arbitrators, and we're becoming a little bit more generous. We add the tribunal secretary. But there are so many other participants. So we've heard from an accountant who is an expert, and they're the ones who seem to predict the future, depending on what tribunal you get and what the tribunal buys into. You might find yourself paying, spending $40 million and being indebted to 9.6 billion. That's the P&ID case. It depends on the tribunal you get. And so those are important. And we shouldn't forget, of course, we have the disputants themselves, and we have the in-house counsel, and we have those who do research. and who do academic work, who teach. And so the question that I've been asked to look at is it really, do you need to study arbitration to become a member of this arbitration community? So I'm going to just use the word arbitration community to look at the more diverse nature of members of that community. And of course, the first answer is absolutely not. You don't need a university degree, or you don't need a legal qualification to become a member of the arbitration community. I think that's the first point. But, and it's uppercase, all uppercase, but. And so that's the caveat. The key question then becomes the nature, looking at the nature of this community. And this is a community of highly educated people. Members of this community, whether they are experts, whether they are legal practitioners, they are really, really highly educated. So clearly, a good education is massively important. And Madeleine already told you that I teach arbitration at SOAS. One of the things I say to my students when I introduce them to arbitration, I say, you can get anybody you like to resolve your disputes. And where the room that I teach in, just outside, is a bus stop, a bus station. So I said to my students, you can be a bus driver and say, hang on, we have a dispute and we trust you. We want you to come and resolve our dispute. And they look at me like, why would I want to do that? And that is the question. So it depends on what do you want? What bit of that community do you want to belong to? So if you are an accountant, there's a role for you. If you are an engineer, there's a role for you within that community. But you then have to determine within the community itself, which roles, because we have different roles within that community, do you think you would be best suited to? It might be as arbitrator. I sit as arbitrator. I don't practice as counsel at all anymore in whichever jurisdiction. But I sit as arbitrator. I do research, I teach, and I train in arbitration. That's 4 different roles within that same community. Andrew is talked about. He does expert work. He trains. He teaches. So he already has 3 of those of that bit that he does. Medina does counsel work. Maybe she sits as an arbitrator. She would train because she's in a law firm, so she would train her juniors and all of that. And we all publish. So you can see, I know that Madeleine is the tech person. You know, she does this online dispute resolution. We have Wairimu, who does arbitration as well. So this is a career space that we're looking at. So I think for me, the first thing you need to ask yourself individually is, what part of this community, what role within this community do I feel suited for? Do I think that I would want to participate in? So for example, Medina might love counsel work, and maybe where she is in her career, and by the way, lawyers, counsel, they make more money than the arbitrators in arbitration. So if money is the major goal, think of becoming an expert witness or counsel, and leave the decision making to some of us who also have another job. But on a serious note, it's important. These are things to think about. So do you need a university degree? For me, we now teach arbitration at the university level, and I think that helps improve the quality of what we have of members of this community of ours. So I think it's important at what level. For me, my personal preference will be right from the undergraduate level, because it's massively important. The way we're trained as lawyers, at least on the continent, and even for us here in the UK, is we prepare people as litigators. Or for those for law students here as solicitors in law firms. But those are not the only roles, and we're actually moving the bar a little bit to dispute resolvers. Do we need to wait until there is a dispute to engage with the process. I don't think we need to do that. So my preference, and as far as we do teach arbitration as a final year undergrad module, because we have to prepare our students to participate effectively in law firms or in-house, wherever they find themselves. But for most institutions, they teach it on the postgrad level. And why it's also useful to do on the postgrad level is, for example, someone like Andrew, who's an accountant, might want to do an MA in international law, and then in that can then do an arbitration module, if that's what they want, without having to do the whole gamut of LLB and all of that. So, Madeline, I think I should keep quiet now.
Yes, Doctor, you preempted my questioning, but I'll maybe remodel it to look at and focus on the African continent and the research that you have been working on. And of course, I know that you've recently launched your yearly survey report. I, for one, being an East African and understanding the universities that we have in place with regards to law now, the university providing that legal curriculum, we have not seen this being accommodated within the curriculums, providing that that knowledge first, not only practical but theoretical sort of knowledge, as the way we would wish for it to be, and also now moving on to arbitration specific causes, that is even also lacking. So you've already explained the importance of it to start from the university level and the postgraduate level, being that arbitration, really anyone can pick it up at any stage, and so they have to have that optune at each stage. How would you think the African now continent and the universities and other academic bodies can adapt to this structure that we're seeing in the West for us to be able to now advance, and the students coming out of the having a law degree, having that knowledge that you would need for you to now have a good practice in place?
Okay, so thank you, Madeline. So one of the key things is that whichever jurisdiction you are in, it's a lot easier to sort of set up a specialist course or program or module at the postgrad level. So and then, because again the LLB, so if we Andrew, forgive me, let me just use law as an example that I'm familiar with. So in most jurisdictions, the law degree is a set curriculum, in the sense that there are basic courses that you need to take. It limits the number of options you might be able to engage in on the undergrad. Remember what I had said earlier on, because of the way we've designed our law curriculum, it's to prepare for a particular part of the legal profession. And so what happens is that even for us, we sort of started teaching arbitration on the postgrad level. And then gradually, we have it as an option on the undergrad, and that is important. So that's one way to go. But for me, I don't think that teaching arbitration should just be as a theoretical subject. It must have a practical, clinical element to it. Otherwise, even where you have knowledge of arbitration, so you have a theoretical knowledge, you do need the training dimension of it. And that's where the Chartered Institute of Arbitrators come in. That's where your own center and other centers on the continent engage with that. So we have quite a number of providers on the continent. Okay, so they're concentrated in the major economies, as you can imagine, who provide training on arbitration. And then you join arbitration organizations where you sort of attend seminars or you attend conferences such as this, and you pick up on what is going on in the field of arbitration. For me, I don't think it's enough to just sort of pick and choose and dabble into it. I think that a structured course of learning is really helpful, because once you understand and you can push and you can query, and you understand the basis and why we do what it is we do, it becomes easier for you when you enter into practice. That's important. And having done all of that, how then would you become a part of this community that Andrew had referred to? And then there are various ways. For a lot of lawyers, it's because they end up working in a law firm. So Medina would I'm sure she would relate to this. Most of us was when we were in legal practice. For me, I started out in legal practice, and that's how I got into arbitration. And well, maybe not now, but if a couple of decades ago, a lot of practitioners stumbled into arbitration. A client walks in, and most of us had no clue that there was something called consensual arbitration agreement. You just look at the contract and there's an arbitration agreement. You sort of get on with it. But you can't just get on with it now, because there is a clear course of training that you can undergo that would prepare you, that would give you better understanding of what we mean by party autonomy, and why is party autonomy that important. Medina talked about that and referred back to party autonomy. So I think that's one way, through legal practice, or you join a firm of accountants who play with figures, or you join NMPC. I can see that Ahmad has finally managed to join us. You join NMPC, and you work in-house or companies, and that is important. Or you work in an arbitration center. And quite a number of students now do internships. And what that, I think I would very much encourage that. So you can do internships with any arbitration centers across the world, because what that does for you is that it gives you an insider's insight into the workings, the practicalities of arbitration.
Thank you, Dr. Amelia, and thank you for highlighting those different avenues for one to be able to access arbitration practice, be it from the in-house counsel work that you do, or the law firm, being employed by a law firm, through those expert witness firms such as the Secretariat, and it really is a wide community. And it is just your way of your selection on how you transition to this arbitration community. Now, we have been joined by Ahmad Khalid, and Ahmad Khalid is dialing in from Nigeria. He will be speaking to us on the perspective of a government state counsel. Ahmad is a Nigerian lawyer that was called to the bar in 1991. He is the current GM, Litigation, Arbitration, Property and Environmental Law Department of the Nigerian National Petroleum Corporation. Ahmad, can you hear us?
Sure.
Ahmad, can you hear us, Mr. Khalid?
Yes, I can hear very well. Good morning, gentlemen.
And ladies.
And ladies. I've been trained to call everyone a gentleman.
Thank you so much for confirming that you can hear us.
Thank you. Thank you.
With your work at the NPC, can you give us some insights and your perspective as counsel under that organization, please?
Yes. Good morning once again, gentlemen. Good afternoon, gentlemen. In NMPC, we do a lot of arbitration.
Unfortunately, I cannot hear Mr. Khalid.
I can hear.
We can hear.
We can hear.
Can you hear me?
Yes. Some of us can.
Yes. What I'm saying is that in NMPC, being one of the largest organizations that is in Nigeria, we do a lot of arbitration in our contractual relationships with third parties. Third parties here could be local or foreign investors. And it is just a common agreement by the parties that for them to resort to litigation, they will rather resort to other alternatives of settling their disputes. One of the alternatives could be that they negotiate or they try to settle their matters through mediation and other forms. Unless those forms have failed, then we will resort to arbitration. The nature and form of the arbitration that we normally do will also be determined by the parties themselves. In a formal arbitration, usually that requires the participation of international investors, we will be guided by the 1996 exit rules, which is a convention that is acceptable by all the parties. And so we either isolate the arbitration clause to be a separate dispute settlement mechanism, or we embed it in the contract itself. And like every other contractual agreement, there has been disputes. There has been disputes in the last 30 years involving our various contracts with third parties. And NMPC has been doing fairly well because when the dispute arises, it will always show that the dispute will arise because someone is not comfortable or pleased with what has happened. But after a duly processed arbitration, the awards are in most cases favorable to NMPC. We have won several arbitral awards in favor of NMPC. We have also lost a number of them. But our major challenge, really, as a government, one of the agencies of government, is that, well, I would rather say our challenge as a corporation is largely on the enforcement. There are arbitrations that we have won. For instance, we have just last year won an arbitration of $7 billion, and we're still trying to see how we'll enforce this arbitral award. Incidentally, most of our arbitrations are premised around our businesses on joint venture operations, on joint operating agreements, and most importantly, in our production sharing contracts. The 1993 production sharing contract that we had with several international oil companies had certain peculiar things that I could call defect in court, which the other parties were agreed with, and it has to do with fiscal regime. It has to do with our taxations. And so these arbitrations went all the way, and last year, again, apart from the other one I have mentioned that we have won, we've also secured an award in our favor. When it came to, we secured an enforcement, a denial of enforcement way up in New York, and we have also secured favorable judgments in court, because most of arbitrations usually will traverse between arbitration and then dovetail into litigation, and that makes the whole thing extremely complex. But the most interesting part in all of this is that none of our arbitration with third parties has escalated into animosity or a broken down relationship. It will surprise you to say that there are a number of international oil companies that are presently in arbitration with us and also are in prospecting and various businesses with us. In other words, we've been running a very healthy arbitration with all the fairness that it deserves, and it has not distorted our businesses. The major challenge, as discussed by the other speakers, is first of all the choice of arbitrators. We have a challenge on that. And another challenge could be also the choice of experts, just as the other speaker has spoken, and also the issue of witnesses. Parties tend to misconstrue the difference between an ordinary witness and a witness in court and a witness in arbitration. Parties become very, very apprehensive, and it used to be very difficult securing the consent or consent of the parties to testify on a matter involving an arbitration. But on the whole, I can confirm to you that our experience in arbitration has been favorable. It has not led to any embarrassment in the cause or embarrassment to the corporation or to the federal government. Rather, it enhances a smooth relationship. There were also certain arbitrations that, as the parties progressed, we came to realize that we would rather settle out of arbitration. And that was done perfectly well. We call it OML 138, it's not the oil mining disease, where the parties were challenging that they had incurred some pre-production costs and that they needed to be paid. And that was amicably solved with Mobil involved, and we are in business with Mobil on that. We have another arbitration again where we got an award and parties wanted to go back to it and we were able to resolve the issues. What I'm essentially saying is that arbitration in NMPC has not generated that dispute in court that will bring in a kind of adversarial relationship between the parties. Rather, it enhances the relationship.
Thank you, Councillor Khalid. Thank you very much. So what are the challenges that the Nigerian National Petroleum Corporation is facing in arbitral proceedings? Can you talk to us about that?
Yes, as I said, one of the major challenges that NNPC has is the enforcement of the award itself. We have an award that we secured in our favor to the tune of 1.7 billion. And we engaged international experts who could assist in enforcing the award. Unfortunately for us, the party had disposed significant number of assets that we would have gone after in enforcing the award. And so it became very, very difficult for us to get that award enforced. Another angle to the enforcement challenge is that the party will go to the court to secure an injunction restraining us from making such enforcement. That is one other challenge that hinders our enforcement. And as I've said before, we have issue of having convinced the witness to testify on a matter. We have not had. It has not been. It has not been an easy ride to be able to convince parties to that. And then we also have challenge as to the documentation. As the arbitral proceedings commences and it keeps going on and on, we will be saddled with the need to provide substantial number of documents that will be required in prosecuting or proceeding with the arbitration. For the fact that some of these matters could be prolonged for several years before now, we used to have a lot of challenge when it comes to securing these documents. We also used to have challenge when it comes to the parties consenting to the procedure that is going to be adopted. The procedure could be at the commencement stage or at the award stage or at any stage. Then, as I said earlier, we also used to have a problem with appointing the arbitrator, either an appointment by the parties or by the panel themselves. There used to be a lot of issue of conflict. There were times we had several challenges being able to get an arbitrator that is not conflicted. And I think the reason for this is because most of the cases are rather generic. They all look similar, and therefore it's the same charter arbitrators, the same fellows, the same experts that we use. And oftentimes you make a selection of arbitrators, and then the next thing you will see is that they will come back to say that they are conflicted and will therefore not be able to participate in the arbitral proceedings. I think these are the major challenges that we have. Hello?
Thank you, Council. Thank you very much. We've heard of the challenges of the prolonged procedure.
I cannot hear you.
Represent your
Madam Madeline, I can't hear you.
And
I cannot hear you, Madeline.
The challenges with regards to the witnesses and consent of
I cannot.
Being a challenge, which I think more jurisdictions, the state council will be on the right page with you. Can you speak on the lessons now for the councils that are participating today? Can you highlight on the key lessons or takeaways from your experience representing the state?
One of the lessons we have learned, as I said, is that arbitration in most cases leads to multiplicity of cases, and that complicates issues. So you will now find yourself from an ordinary arbitration or arbitral proceeding ending up into litigation way up to the Supreme Court. Parties, as the matter progresses, will raise fundamental issues that could only be resolved in a formal court proceedings. So the arbitration will now stand down for the matter to be disposed at the court. One, as I said earlier, it could be as a result of enforcement. Another could be challenging the credibility of the arbitrators that have been chosen. We had an arbitration where we had to challenge the credibility of the arbitrators because we have discovered that they were conflicted in some other arbitrations, and that material disclosure has not been done prior to accepting to be arbitrators. So that's part of the lessons that we have learned. And we have also learned that if we could settle by ordinary mediation or discussion, we will have succeeded better than going through the whole hog arbitration, because we normally get stuck when it comes to enforcement. As I said to you, we had an enforcement where the assets we were going after were no longer available. And the other lesson we have learned is that our contract agreements should be very, very concise to accommodate all issues that could lead to disputes. Now, the 1993 production sharing contract, which led to a number of disputes or arbitrations involving about 5 to maybe 10 IOCs, originally came because parties had issues with the contract they both agreed and signed. So we have now intensified our negotiations with the parties so as to ensure that we produce a very, very concise and clear contract with clear terms and conditions that will be devoid of any issue that could lead to arbitration. We have also learned that the arbitration we have adopted could be very, very costly because of the other incidental issues that dovetail into it. One of them, as I said, is litigation. And then, of course, the issue of enforcement, parties seeking to take an award from a particular jurisdiction to another jurisdiction to ensure that the enforcement has been made. So you will now be saddled with engaging a local counsel with the experts as well as a foreign counsel in a particular jurisdiction to fight and challenge the enforcement way up to the highest court in that jurisdiction. Now, so this has made the arbitration to be more complex than we have actually imagined. And because of that, also we have learned that the duration may not necessarily, despite a defined procedure that we have, the duration may not be necessarily as we have envisaged. We are into an arbitration now that has lasted for over 2-3 years because of several procedural irregularities that kept coming in and out of the arbitration. I wouldn't want to talk about fees as a challenge, but of course, the fees, which is tied to the costs I have mentioned, could also be a challenge, because as you delve into this arbitration, you could have a budget that tells you that within a particular range, you should be able to exhaustively address all issues with respect to arbitration. But when litigation issue comes in, the issue of payment for the venue, payment of the arbitrators, experts, and all that, it overshoots the budget. Then parties will begin to wonder whether they should have resolved this matter by mediating or just negotiating or settling without resorting to the arbitration. I think these are the major lessons I could rather say, in addition to the fact that the outcome being an uncertain, when you have an uncertain outcome, it truncates your future relationship with the company. If you have SPDC, Shell, or Mobil that you are transacting with, and you want to start prospecting into other fields, and you are negotiating and you're trying to get the heads of terms and then get into a new prospect, but you don't have an arbitration between you on other fields, which has a very, very unfavorable outcome or an uncertain outcome. Parties that are trying to prospect into a new business will always be apprehensive in getting into. So apprehension is one of the key lessons that we have learned. Uncertainties in the outcome of arbitration. Thank you. I hope, gentlemen,
right.
You've had me?
Yes, we have had you. And I now invite Madeline to take us through the Q&A. Do we have any questions from the chat? Or have speakers addressed the questions on the chat? If I can get a quick thumbs up or thumbs down. Are there any questions on the chat, or have speakers addressed all the questions? All right. So what I'm hearing is that all the questions seems to have been answered from all that the speakers presented. I would like to thank Madeline Kimei, who has greatly and very ably handled this session. Thank you so much, Madeline. Thank you, Andrew McClay. Thank you, Dr. Emilia Onyema. Madina Chenge, thank you very much. Mr. Ahmad Khalid, thank you very much. I'm sure you will all agree that this has been a very, very enlightening session. Our next session is going to be at 3:30 p.m. EAT. That's in about 12 minutes time. Please join session 2. The speakers are waiting. We're going to start, like I said, the session in about 10 minutes time. Please join me in thanking the speakers who have ably taken us through perspectives from a government state council, perspectives from a law firm that does both national work in Tanzania and international work, part of the DLA Piper Group, NNPC. We've heard about all the arbitrations that have taken place. Andrew McClay, forensics expert. Emilia Onyema, lecturer at SOAS. Thank you all very much. And I am stopping the broadcast very shortly. And I would like to invite you all to join the next session starting in 10 minutes.